Hey, we're delighted to have Paula Camper with us. She's an extraordinary scholar, which you've seen through her report, and a huge asset of the National Center. Has been for how many years?
33.
Do we also have Miriam Hamilton?
Yes. That's my colleague, Miriam.
Hi, Miriam. Great to have you with us.
Yeah, delighted to be here.
Okay, the floor is yours.
Okay. Thank you very much. Thank you for the council for allowing me and us to come back and talk to you about the most recent evaluation that the National Center has done on your Rule 26 and some of the other reforms that you put in place around civil discovery. I feel really invested in this. I was actually part of the group from the National Center that was sort of riding shotgun with your Civil Rules Advisory Committee in 2008 as you were debating the actual what the rules should be and what does proportionality look like and how do we get the rest of the bar on board. And then when you put the rules into effect in 2011, we had some funding from the Bureau of Justice Assistance at the Department of Justice to do an evaluation of those rules, which was then that I was directing that particular project, and so got to direct that evaluation that was published in 2015. And so I'm just very invested in like the whole topic of Rule 26 and how this has gone. I don't know if those of you who are sort of in the trenches here in Utah were fully aware of what an impact those rules had on civil justice reform nationally. When the evaluation came out in 2015, at the time there was a committee of the Conference of Chief Justices called their Civil Justice Improvements Effort Initiative that was looking at civil justice reforms, and they were so impressed with the sort of tiered approach to discovery that they basically made that a fundamental, part of their reported recommendations that was subsequently endorsed by the Conference of Chief Justices and by the Conference of State Court Administrators and the State Justice Institute, which had funded a lot of this work. Then put $1 million into actually spreading this, the whole tiered discovery and discovery reform, as well as some other aspects nationally, and had a huge impact in terms of the way that not only state courts, but also the federal courts started adopting much more tentatively, but started adopting some of these reforms. And so later on in that process, and particularly after COVID, with a lot of concerns around the especially civil justice backlogs, the State Justice Institute came back to the National Center and said, we think that there's a real opportunity. We know some of the work is stalled because of all the focus on criminal backlogs as having priority. We really think that this is a way to do it, but what we think would needed is basically to go back to use and prove just how well this has worked. And so GI gave us another grant to be able to come back in and look at this again. And so next slide, please. So what we ended up doing is sort of looking just at the civil justice. And what we really wanted to do was, first of all, sort of look at what we had done before in 2015 in terms of that evaluation, and see whether, to what extent that Utah was able to sustain some of its early successes. What we found in 2015 was significantly reduced time to disposition for cases. Settlement rates increased dramatically with dismissals and judgments going down. Really high attorney compliance. I think that was one of the big concerns in 2015 is like, are the attorneys actually even going to comply with these rules and these timeframes? And particularly on the scope of like, how many interrogatories can you do? And so we were surprised at that point, we were very happy to see that the attorneys were complying at that point. We also found that discovery disputes, they actually went down for tier 2 and tier 3 cases. They actually went up with tier 1 cases, which, given how many of those are debt collection, might actually be a normatively good thing in terms of litigants actually starting to ask questions about what is the basis for some of the debt collection actions that might have been happening in tier 1. But we did find that the time frame actually moved up about 4 months earlier for discovery disputes. So obviously the attorneys were jumping on things. So we really wanted to look this time around of whether or not those really impressive results had been sustained over time. But the other piece that we were very interested in, partially because when we were doing our data collection with judges and with attorneys in 2013, 2014, they were still new enough. And there was, I think, some hesitancy on the part of the judges of, well, the Court of Appeals and the Supreme Court have our back if we have rulings of trying to enforce some of these. The attorneys were still trying to learn how did they manage with new timeframes. And so we really wanted to look at very closely at what, once you started getting further out there and people were more acclimated with the rules, what did they actually think about them now that they're sort of have become, this is how we do things in Utah now. So we really wanted to look on the practical level of not just what was happening in courts, but also how is this affecting the civil bar generally. We were very lucky to have a wonderful advisory committee from folks here in Utah, both from the Civil Rules Advisory Committee, from the district court judges, as well as some outside folks outside of Utah that were very interested in civil justice reform. And so we worked with them to actually help put the evaluation in place and how we were actually going to approach it. So Miriam, you wanted to talk a little bit about how we did that.
Yeah, next slide, please. So let me tell you a little bit about the data and methods that we use for this current evaluation. And essentially, we replicated the methodology that was used in the 2015 study. So we had an analysis of case level data pulled from the CORS system. We conducted focus groups with district court judges and attorneys, and also distributed attorney surveys. We modified in a few places to address some gaps in the prior methodology, and also to adjust for the much longer time frame that we have this time around. So we pulled all general civil cases that were filed between 2013, January of 2013 to December of 2019. And so that allowed us now to also include the more complex cases that and see them to the end, because of the longer time frame, they had more time to resolve. Those types of cases tended to be pending still in the earlier evaluation. So those are included. And you will also know we cut off the time frame December 2019 on purpose to avoid the pandemic that happened right after. We only looked at contested cases, so we filtered out all uncontested cases, that is, cases where the defendant failed to file an answer. That information was not in the regular CORS data set that we received, but we had a list of document titles that were filed. And so we searched for keywords and phrases in those document titles that would be associated with an answer being filed. And so those were the cases that were associated with those document titles were the ones that were included in our analysis. The case types that were included were tort cases, contract, both debt collection and non-debt collection contract cases, property rights and water rights cases, not domestic relations cases this time. And we had we started out with roughly 500,000 filed cases, just under 62,000 cases had an answer. So that's an answer rate of 12.9%. And that answer rate, there wasn't really an increase or decrease over the years in our sample. However, the answer rate did vary between the tiers. In tier 1, the answer rate was 11%, in tier 2, 51%, and in tier 3, 70%. I also note our sample was heavily dominated by debt collection, and 76% of all of our cases were in tier 1, 12% in tier 2, and 10% in tier 3. And half of the sample of the cases originated in district 3. So that's just giving you a little bit of the context for the case level analysis. Concerning the focus groups with the district court judges and civil attorneys, those were designed, as Paula already mentioned, to kind of both focus on the out of court experiences of the attorneys, but also case characteristics and outcomes that may have been impacted by the rule changes. And the insights that the judges had about the attorney behavior, those insights in turn informed the design of the attorney surveys. The attorney surveys, that was also something that was part of the earlier study. However, back then, those surveys were distributed on a rolling basis so that NCC could ask the attorneys about case details that weren't in the course system. This time, with the longer time frame, 2013 to 2019, we couldn't really expect the attorneys to remember all those details from, back in 2013 maybe. And so the survey questions were much more general, asking about their opinions and experiences about how the rules may have affected their experiences. And as far as the respondent sample goes, we ended up with 491 respondents. 3/4 of them were from district, the 3rd Judicial District. Most of them, or a lot of them, had mixed legal practice, and 44% had more than 20 years experience. Next slide, please. And of course, I'm going to tell you some of our most relevant findings. The first one to highlight is the great improvement in discovery tier assignment to start out with. So that was something that was actually still quite inconsistent in the earlier study. This time, however, almost all cases in our data set had a tier assigned, 98%. So that was very, very positive, and just a sign of how the Utah Judicial Branch had continued to invest in the functionality of the course system to improve case management for civil cases, including the automatic generation of the due dates. And so, the tier assignment was the first major highlight that we saw in our data. Looking across different case categories, those were quite predictive of the tier assignment. As you can see in the graph, 96% of debt collection cases were in tier 1. 68% of all property and water rights cases were in tier 2. 43% of tort cases were in tier 3. Non-debt contract was a little bit more divided among the different tiers. The biggest proportion, 39%, was also in tier 2. The other thing concerning tier assignment that we found was what we call tier inflation. And that was already a significant finding in the prior study, where plaintiffs had alleged higher damages, supposedly to obtain the greater scope of discovery than what would have been permitted under Tier 1 or maybe Tier 2. And we found that this trend had accelerated in our current data even across case types, but especially Tier 3, especially tort, non-contract debt non-debt collection contract cases. Across the entire sample, we found that the proportion of Tier 3 cases among all the cases went from 2.3% in the post-implementation sample of the earlier study to 7% in 2013, and then almost doubled to 13% in 2019. So quite an increase. And as you can see in the graph there, which shows just the tort cases, we do have kind of an increase in the overall tort volume of cases. But you can see with the line graphs there, we have the showing the Tier 1, Tier 2, Tier 3 proportions. The black one, the top graph, is the Tier 3 proportion of tort cases. You see how that has just been gradually increasing across the years. It kind of makes sense thinking about the different case types, that some case types would be more susceptible to the tier inflation. If you think about debt collection cases, the damages are often more concrete. Towards non-debt contract cases are just more abstract, maybe the damages, loss of profit, non-economic damages. So those types of cases are more susceptible to having that higher tier. Then next slide, please. We also looked at the manner of disposition and found that similar to the earlier study, the settlement rates kept on increasing. So they went to 42% and became the most frequent manner of disposition. We also found that the judgment rates kept on decreasing from 46 to 38%. However, unlike the earlier study, dismissal rates actually decreased in our sample. Not quite as much, but from 24 to 20% in 2019.
How did you distinguish between settlement and dismissal? A lot of times we see them come through as a motion to dismiss because of settlement. So how did you distinguish between those two?
So I think we were looking at the whatever the final disposition, we were looking at actually keywords again in those. And so there were certain ones that if it was a dismissed with prejudice, is usually a good proxy that this has actually been settled. Dismissed pursuant to a settlement. So if there was some sort of language in there, as opposed to just dismissed without prejudice, was usually sort of the piece. The other ones that we included as settlements was anything that was an agreed judgment. I think was another.
So stipulated judgments and those are counted as settlements.
Those are counted as settlements.
Judgments essentially would then be just trials or adverse, non-default dispositions.
Yeah, and we would potentially could be having a default, but if there had been an answer filed, but because of some type of, just the defendant disappears.
But you had engagement.
Yeah,
So default is non-engagement. And those judgments would be, it may have ended up being called a default, somebody didn't show for trial or something,
exactly.
but there had been engagement.
There had been engagement early. Summary judgment would be in there for the for the very small number of summary judgment. You don't have a lot of them here in Utah. But yeah.
All right, go to the next slide. So time to disposition, that was the one that we were really curious about. As Paula mentioned, that was highlighted in the earlier study, how that time had been reduced in the post-implementation sample of cases. What we found this time around was that overall there was an increase again in the time from filing to when the case was resolved. And we found that across case types. And so that was unfortunately a finding of, where just the earlier success apparently was not sustained since 2013. What's more is that we found for especially the tier 2 non-debt contract and property and water rights cases, those cases took even longer to dispose than those types of cases had taken in the time before the rule changes went into effect. So it takes now even longer. Most likely due to a lack of compliance or lack of enforcement, but we'll get to that a little bit later. We looked at other different milestones in the case management, the progression, and just to find some clues as to why those cases took so long to dispose. So we looked at cases that where there might have been extraordinary discovery. Again, that was something that we we deducted from looking at document titles. And we found that only in 2% of cases, there was a motion or stipulation for extraordinary discovery. And those motions were usually always granted. And for those cases, it makes sense that those take a lot longer to resolve. However, we also found that even in cases without the extraordinary discovery, even those took a lot longer to resolve. And as you can see in that bottom graph on the slide, those are the median time to disposition in days. The blue bars are the ones with extraordinary discovery, and it's clear those take a lot longer. The orange bars are the cases without extraordinary discovery. And if you take tier 3, for example, the median time to disposition is, over 500 days. And that's just the median. That means half of them took even longer to dispose, right?
So if they effectively got extraordinary discovery, but they didn't call it that, they moved to amend the case management order or move to extend the fact discovery deadline, would those be captured in what is essentially extraordinary discovery?
Do you remember what we were, this was another one that we were using sort of keywords that we were looking for, motion to extend, motion to.
Okay, so it was broader than just the words extraordinary discovery. Okay.
Okay. It could very well be that we didn't catch. Yeah. And so that was kind of the one clue that didn't really explain a whole lot. And so we also looked at if certificate of readiness were filed and when they were filed, orders to show cause, and I'll let Paula tell you a little bit about what we found there.
Okay. So one of the things that we were, even in 2015, supposedly once the attorneys had finished all of their discovery, the rule states that you were required to file a certificate of readiness for trial. And in the 2015, we found that was routinely not happening at all. So one of the good things about this one was that there was a larger percentage of cases in which a certificate of readiness for trial was filed.
So 11% is the larger number.
That is the larger number. Okay. And these were cases where the case had not already resolved by the time the deadline had come and gone. So it was, that was an improvement over 2015 in terms of there were more attorneys, a larger percentage of attorneys that were actually filing their certificate of readiness for trial. But the timeliness in which they did it was actually much worse. We're seeing that I think it was only about 55, a little over half were filed within 90 days of when the certificate of readiness for trial was due. And fully a quarter of those certificate of readiness were filed after 9 months after the due date. So this is not particularly timely in terms of when the rule says that that was supposed to have happened. And so this was, this was sort of a one of those things that we started to look, obviously this is quite clear of like, why are the cases not disposing when you actually have these deadlines that seem to be going by without any type of sort of notice or enforcement happening by the court. So this is where we really tried to spend a fair amount of time, probably the whole second half of last year, was digging into the data to try and figure out what was going on. One of the things that we really wanted to look at is, so if the judges are paying any attention to this at all, wouldn't they be regularly issuing orders to show cause of like, hey, you got a deadline, where is it? And so in those cases, 89% of cases where there was no certificate of readiness for trial, we saw orders to show cause filed in only 3.5% of them. So this is not, there doesn't seem to be any follow-up whatsoever happening at the district court level, paying attention to some of these deadlines. Yes, sir.
I don't ever do an order to show cause in these cases, but what I always do is set a status hearing.
Okay.
And so that might be why you don't see an order to show cause is my JAs will alert me that the COR date has passed or is approaching, and then they just set a status conference and bring counsel in front of me within the next 30 days to tell me what's going on.
Okay, all right. That's good to know.
And so was this another one where you folks did the sort of keyword searching and were you looking for notices of intent to dismiss? Because that's the other thing I know. Second district will send out a notice of intent to dismiss for failure to prosecute, but not in order to show cause. And then tell people you've got to respond to us within 60 days to tell us why your case hasn't filed a certificate of readiness. So is it another one where you were doing keyword searches, and how broad were the keywords you were searching?
I think we were mainly looking for order to show cause. We had asked our advisory committee about what should we be looking for in terms of these, and that was the one that they told us. So there may be actually more enforcement going on, but it's
At least through that method.
at least through that method. So anyway, we spent a fair amount of time just trying to dig in and find out what was going on. The other thing that we looked at, in terms of the order to show cause, is that it didn't seem to have any relationship whatsoever with what the final disposition date was. So they weren't being filed very frequently. Most of them, like 2/3 of them, were being filed well after the COR was actually due. So it wasn't clear that this was actually a good proxy for thinking about whether or not it was actually getting the case moving again. The other thing that we looked at, and this is just where we saw an order, a certificate of readiness filed, so that 11% of cases, of just looking at the actual disposition date, and we were very surprised at how long it was taking the cases to actually dispose after the attorneys had filed something saying, oh yeah, we've done everything and we're ready to go now. On average, across all of our cases where there was a certificate of readiness filed, it was taking an additional 7 months to actually get the cases fully resolved. And it actually differed in terms of what the manner of disposition was. So if there was actually a judgment in the case, it was taking an additional 10 months. Settlements took about 7 months. The 10-month for the judgments, we did take a look into the small percentage of cases that actually went to trial, either a bench or a jury trial. Bench trials were taking 8 months from COR to when the trial took place and the final disposition. Jury trials were taking 10 months. So that makes some sense. We actually wondered if what might have been happening is just calendaring practices. So the COR comes
I
in.
want to go back to this moment. I was striking really fast.
Mhm.
You only had third district judges on the advisory. And so this issue of nomenclature as to
Big deal.
what you call things,
Mhm.
is culturally a big deal in Utah.
Okay.
Because we speak many languages, third being only one of them. Fourth and second are totally different.
Well, and
We've heard that.
and the hinterlands are even
Okay.
further different, but I think that this order to show cause thing, the notice of intent is also ubiquitous in the fourth district, so
Okay.
you may have had out there a rather large body of what you would probably think is an order to show cause, but those words don't appear in the notice,
Noticeable
so,
violence.
yeah,
Okay, thank you.
sorry.
That's okay. It did make us think that there may be some issues around calendaring practices that are going on, that once the certificate of readiness for trial, they're just like,
Calendaring constraints.
Yeah, I'm not sure it's practices.
It's not practice, it's get in line behind the criminal cases.
And it's
Okay.
get behind, line behind
Everything.
everything else on your calendar. It's hard to set something less than 6 months out.
In these types of big civil cases where I've tried to set them, even if I have a week, depending on the size of the trial, much sooner than the attorneys do.
Yeah.
They've got trials all over the place and they're asking me to set them out.
Witnesses.
And by the time we get everybody lined up, it takes that long for me to have a place on my calendar that they all have a place on their calendar.
Of interest is general length to disposition via trial,
mhm.
and the general disposition length for settlement is the same. Why? Well, because we were right there at trial, and now it's time to settle.
They were settling the day before trial.
So that's, I mean, Rita and I are looking and going, yeah, it pretty much lines up. I mean, the length of time to get to trial is gonna be constraints. Bigger the case, the more attorneys, the more witnesses, the longer you're gonna try to give them a week or two. And anything shorter than that, it's getting in line behind criminal and everything else, it's taking up trial calendars.
Well, and then in the run up to trial, they're gonna make their best chance of settlement in the 2 months before, so that they can avoid the work of preparing for trial. So that doesn't surprise me.
And is that also true for, so that we had a lot of them that were judgments that were non-trial, like judgments? And so does the same thing happen if there's like some sort of final hearing that might
Summary
also
judgment
be?
might occur sometime in that timeframe as well.
Okay, so that they are being set out. The one thing we were kind of curious about, so settlements take 7 months. And so it's like, okay, you were ready to go, but still needed to talk for another 6 or 7 months to figure that out. And this is again the median, so some of them took longer.
That's 6 to 7 months I get to use the interest on that money, right? I mean,
Okay. I was curious about this dismissals, because those actually took a full year. So cases that are being dismissed, taking a full year, and I wonder to what extent are these cases where, in fact, the parties have actually reached a settlement, but they're holding it on the calendar, holding it on the docket open while the terms of the settlement are being complied with, as opposed to just entering a settlement and then if something happens. So I just speak for myself after, doing court administration for now 33 years. That's not really an ideal practice for courts to be allowing to happen. You may have a different cultural view here in Utah, but it hurts your numbers. Is there a particular reason for doing that other than the fact that it gives the parties the leverage of like, yeah, if you don't satisfy the terms of the settlement, then then we can walk back into court.
they're not bothering us.
They're not bothering you.
That's not a case that either side is kvetching about moving forward. And at some level, liquid finds its own level. I mean, I like one of your, at the end, we'll get to the recommendations. One of them is maybe our timeframes are off. Like, why? Because if our timeframes are too short, lots of courts are going to recognize and start to feel that from their practitioners. These timeframes are too short. We're not going to be super excited about enforcing hard deadlines because the timeframes are too short. So if the timeframes are expanded a little bit, then you would find more enforcement tighter to it. Because at the end of the day, what our rules are going to always try to do is keep everybody in the roadway. There will be extraordinary cases over here, but if the roadway is way too narrow, then that's not gonna help us either. But, I mean, I think these are not, I don't do civil litigation in this context, only in small claims. But to the extent we have a case on the side that's hanging out to get paid, to get dismissed, no real skin off our nose. A little bit hard on my numbers maybe, but I'm okay because we're a dispute resolution system for parties and that dispute is getting resolved.
Next slide. So we did, we obviously asked the attorneys about, what this actually meant for them. Interestingly enough, when we did the attorney surveys in 2015, there was a lot more sort of angst about what these rules were actually going to look like. What we found here this time is your civil bar actually really likes the rules. They like Rule 26. When we asked them, we had both an open-ended comments as well as, especially the focus groups, were saying that this is so much better than practicing in federal court or, when we have to go to other states. They actually really, really like the rules. Younger attorneys are especially very comfortable with the rules. They think they're pretty good. Some of the older attorneys, a little bit less so. The majority of them still like them, but there was a noticeable shift. And so some of them may not have acclimated quite as well to the new rules. Most of the attorneys actually said, when we asked about the timeframes, and we're certainly interested based on what we were seeing that okay, nobody's actually making these timeframes. Most of the attorneys were saying, yeah, these are actually about right. We think that the timeframes for all three tiers, there was a sizable minority, probably about 30-40%, that said, yeah, they're a little bit too short, but they weren't asking for another 6 months or another 12 months. It was just for the tier 1 and tier 2, they said we could use about another 60 days. And for tier 3, we could use about 90 days in terms of where those discovery cutoffs are. So some tweaking, but not a lot. We were kind of interested in why the younger attorneys, some of it may also reflect the fact that your younger attorneys are probably working on less complicated cases because they're just newer and younger. But we also think that some of them are just that the rules themselves actually are clearer and more straightforward and give more direction. And so they're just actually easier for people to learn and to keep in their head. One of the things that did come up in the focus groups was particularly, especially from older attorneys who remembered with, the rules, if there was going to be any change to the rules, they only happened once a year, and you just had to learn, here are the new rules that are coming out of whatever, and you just learned them. There was a big CLE, and you just went ahead and learned them. Now the comment was we get new rules all the time, and they're really hard to keep track of, what's changed this time. And so part of the pushback, I think, for the younger attorneys is because these are actually really straightforward. We don't need to keep track of where the tweaks are being made because they're just not being made that much. There was a lot of concern early on about mandatory disclosures and how those would work. By and large, they really like the mandatory disclosures that don't take a lot of time. Most of the cases are 6 hours or less to actually prepare those, which in the greater scheme of things for litigation is not a lot of time at all. Very useful for looking at the merits of the case. And interestingly enough, very useful for client engagement and education, of talking to the clients about what this case is and what it's going to take to actually prove your case if you're a plaintiff, or defend this case if you're a defendant, what we're actually going to need to be able to do. So that's actually helpful. There was less of a consensus on some of the other pieces underneath. So for example, how often you need to update and do supplemental disclosures, particularly around damage amounts. A big debate going on with the bar of, is it sufficient if you have notice that somebody has been injured and they're had lost wages of X number of dollars a week while they've been out of work? Do I really have to come to you, a month later, 2 months later, 3 months later, and give you the updated number, or can you do your own math? Do you have fair notice as to the, what the nature of the damage is and how to do those calculations? Some are like going, no, we absolutely need to have the updated number. Some are like saying, you've already got fair notice of what's at stake here. Expert discovery, there's still a fair number who really want to do both a deposition and get the report. And so whether or not both are needed. And then how to deal with non-retained experts. Are they part of fact discovery? Or are they part of expert discovery? So those are some of the ones that probably the rules themselves could be improved a little bit. We did see that more than half of the cases actually do require some sort of supplemental disclosure. This is what the attorneys were saying us. So it is kind of a big issue in that respect.
Is the 10% response rate about par for the course? That seemed low to me? This is not my area, but I was just curious.
10% response rate on the attorney survey? Yeah. Next slide.
Yeah, so we also asked about the timeline enforcement with the COR due dates automatically being scheduled now. There are pretty clear guidelines, expectations for when discovery should be complete. However, a little over a third of the attorneys reported that judges almost never or seldom issue case scheduling orders, and we already talked about that might be
Hey, I noted that in your
yeah.
conclusions and recommendations. I'm wondering if that has a direct effect by the fact that our chorus system, when their answer is filed, it kicks out these due dates for the parties and advises them of them. I think a lot of practitioners kind of view that as enough. Do you think that's causing a problem in and of itself?
Enough as in that the guidelines are just out there
Well,
already.
there's dates out.
Yeah.
In other words, they're lazy, and so like, well, we've got these dates we got to work with. Why do we need to go to the court
And have them put it in an order.
and put them in
Yeah,
order?
they get a notice of event 2 days. That parrots back what the deadlines are under the rules. So they know what the deadlines are from the rules, then they get a notice of event due dates from the court. It says, here we're gonna translate it into actual days for you, dates.
Yeah.
February
The
6th,
hard date.
rather than the counts. So why then would they come back to the court to get a scheduling order that then parrots back those exact same dates? So it's not, it's true, it's not a common practice for the courts to issue one, because parties there's no mandatory scheduling conference. And why would they ask for one if they've already got the dates in front of them?
I always treat that as an order.
I mean,
I do too,
I've
when you
seen
can-
cases where they're enforcing those. They feel fine coming in and saying,
Yeah.
no, discovery's over. We got that notice of dates, the date said discovery's this date, we're done. And judges frequently are, that's. So I'm just wondering if that maybe is the disconnect of why you're not seeing formal.
Again, another one where had you asked, are you getting a scheduling order? Or if you asked, are you getting a scheduling order or a notice of event due dates, I think a number would be very different.
What we did find is that there seemed to be a general opinion of that there was some disconnect, that they wanted consistency one way. Whether it was kind of, judicial discretion, whether the judge would allow, untimely or inadequate evidence, or whether the guidelines would be strictly enforced. the overwhelming majority of attorneys wanted consistency and just wanted to know where they're at. But most did want the enforcement, and it does put the attorneys that are trying to follow the deadlines at a disadvantage when they're up against those that are, need more time and they're lax, but also then not knowing whether the judge will enforce it. So there's that, but we'll talk a little bit more about that in the recommendation section.
It's a fun disconnect because when they answer the survey, they say most want us to enforce the deadlines, but when they come to court, a full 50% don't want us to. So
Well, and I think that maybe the 50% that you're actually seeing in court that are coming in that are squeaking, so.
Yeah. There were some regional differences. So in the 2nd and 7th districts, attorneys were more likely to prefer judicial discretion. We speculated maybe it's because those communities are smaller, more tight knit, and maybe they don't need the formal enforcement. It also varied a little bit by client.
Which
base.
second on there?
Second
There's
district.
there's two districts.
Delaware, so
No.
Weber, Davis, I
Yeah.
think break it down that way.
There was also some variation with the client base. So plaintiff attorneys were 2 to 3 times more likely to prefer that the judge would allow untimely and inadequate evidence. Yeah. But again, the largest complaint that we found in the open-ended comments by a quarter of the respondents was that the non-compliance on part of the attorneys and the non-enforcement on the part of the judges undermined the effectiveness of the rules. Going back to just the kind of the divide between the younger and the older attorneys, when asked about the impact on the professionalism, the 89% of the younger attorneys, so those that have been in practice since 2011, 89% of those had a favorable opinion of the impact of the professionalism, but only 42% of the attorneys that had been in practice before 2011.
And so just so we're clear, the folks who have only ever practiced under the rules say it's
the rules
an
are great.
improvement over something they didn't know before, or otherwise 42% that have experience with both say it's less than half.
And again, Paula already mentioned it might be because, well, first they hadn't had the experience of how it was before, but also maybe just they benefited more from the clarity and the streamlined procedures. But most of the attorneys agreed that the rules had a positive impact on meet and confer conferences, case preparation, trial preparation, attentiveness, those kinds of things. And that was it on the findings. We can go into recommendations.
Yeah, we can. So we also, part of the attorney surveys, we also asked for open-ended comments, from any of the attorneys, which is my cynical view is that sort of like you allow the curmudgeons to like weigh in and say how horrible and that the sky is falling and this. So by and large, almost half of the people who took the survey had open-ended comments for it. 1 in 5 of them, fully 20% of them were like, we really like these rules. This is where we were getting, we much prefer Utah's rules than the federal rules or the other states. The single biggest complaint was judicial enforcement. People who are not complying, and we never know whether or not, if we actually ask for some sort of enforcement, it varies from judge to judge, it varies from day to day, whether or not we're going to get the relief that we sought. And so that was probably the biggest complaint that we saw. So just some of the recommendations that we had, we did have some that we were specifically doing for sort of looking at the advisory committee on civil rules. Mary had a chance to address them about a month ago at their regular meeting, and sort of went over some of these recommendations of just telling them about this and how might the rules themselves be adjusted. Obviously, so most people are not actually completing these cases within the timeframes that were envisioned by the rules originally. And so one of the things is maybe it's time to go back and look at the timeframes. Even though you've got most of the attorneys are saying, yeah, they're about right, but but you're not meeting those deadlines now. So maybe it's time to look at adjusting those 2 or 3 months that were recommended in terms of where those were. The other one to sort of look at, and this has to do a little bit with the fact that you're using monetary thresholds for each of the tiers. We definitely had that tier inflation issue. Originally in 2015, we thought that was just people that were trying to hedge their bets. We want to have as much discovery as possible. There was a case out of the Supreme Court, Pilot v. Hill, that basically said, oh, and by the way, this is your cap on damages. And so we think that is actually probably the more motivating issue right now, is if I think that there's any possibility that I could get a damage award into the higher one, then I'm going to allege higher damages, just so that I'm not cutting myself off and cutting off my client from the possibility of higher damage. So maybe it's time to look at those monetary thresholds. There has been inflation. We know about inflation. So maybe it's time to look at some of what those thresholds are and do those. We also suggested that, and we had given the advisory committee, I'm happy to share with the Judicial Council as well, in about 20 pages of all the open-ended comments. A large portion of them were actually some very nuanced and thoughtful recommendations about how to tweak the rules for specific types of cases, and or very, very discrete issues. I obviously don't practice here in Utah, so some of them were like going, okay, I guess that's a thing. But definitely looking at greater direction around those issues around what is fair notice in terms of supplemental disclosures, and giving some additional guidance on that, on the expert discovery, and about when do you do non-retained experts. So those are definitely some. Next slide. And the last one that we wanted to sort of think of, and this is really, so when the National Center sort of looks at some of these civil justice, oh, are we missing a slide? Is it hidden? All right, good. Okay, we have another slide. I'll just talk through it. When we think about sort of the importance of how you do actually good civil justice administration, it's really sort of the interplay between the rules and your administrative infrastructure for enforcing those rules. The rules are what actually tell you, if you're looking at it like an automobile, it'll tell you, how you adjust for the direction and the speed. But it's your infrastructure that actually is the engine that actually keeps you going. So the rules themselves are not self-enforcing, as much as we might like to think so, but if you don't have, if you don't have the right rules in place, then your infrastructure is just going to go nowhere. So the piece that we wanted to sort of bring here, and sort of in light of what the attorneys were telling us about the lack of enforcement, is really sort of thinking on the administrative side of this, because that seems to be the big gap of what we're seeing, that there does not seem, and I take your point that there may be different language. but even whatever enforcement is happening is not actually making these cases move along. So there's still an enforcement gap there. What that does, we think, is actually it probably incentivizes some additional gamesmanship. And this I'm actually taking from some of the other work that I was doing in other jurisdictions that were looking at this, of that what the attorneys think is that when the court is actually monitoring and enforcing its own rules, then those attorneys who just want to follow the rules and just want to get the case done are able to do that without having to worry that, oh, I'm bothering the judge because I need to actually file this motion to compel or motion for a protective order or some other type of enforcement issue that bothers a judge and it takes the case down. And it just makes for some of these just additional gamesmanship, but so if you're not willing to actually do that and take that additional work, then attorneys that are either less either playing games or just less diligent are able to get away with a lot more. So just thinking about those, that this is actually something that if the court is actually doing meaningful enforcement, meaningful oversight, that it can do that. Utah, y'all have put a lot of time and effort into your chorus data set, and in terms of being able to actually do good monitoring. So but I'm not sure that all of the judges actually know what those tools are, or the staff, and are using those as effectively as they could. And so one of the things that we would suggest to you is actually just do some additional training for the judges about how those are, and even automate some of them. If there is, any of you have had like the dentist appointment that you're getting your text message a week ahead of time of reminding you, like, okay, you get a dentist appointment, that's actually the time to be bringing people's attention that this deadline, certain deadlines are due, and letting people know that, oh, and by the way, we're paying attention to that. And those could be actually automated without even the judges thinking that much more about it. The other piece, though, is around sort of that lack of consistent enforcement, of like really not knowing what the judges are going to do, if they're going to allow an untimely disclosure or disallow it or strike it. So we went and we talked to your judicial education folks, and the last time that the district court judges had any education on this particular issue was in 2015, when I came to the district court meeting to tell them about that the earlier evaluation. So it strikes me that there has not really been an opportunity for your district court judges to actually talk to each other about what actually is good cause for allowing an untimely disclosure that would allow for the development of sort of a shared understanding, at least within judicial districts, if not on a statewide basis, of what that would look like, to be able to help some of that. I think those were probably the main issues of you get the tools, but I think you actually need the judicial training to be able to actually do those.
Reach self-represented litigants.
Yeah, so also, so the issue was when you had self-represented litigants who may not actually be in there, but if you're in, was it my court case?
My case.
But just incentivizing your self-represented litigants to be on that so that they can actually get some of the timely notices of, hey, your certificate of readiness for trial is due. And are you, or if you're not done yet, tell us that you need extraordinary discovery. Ask us for more time, or at least communicate with us that you need more time. Maybe put in place some guardrails for how often that those can be done. So those for that. take questions?
Just out of curiosity, so we've talked a lot about time to disposition, right? Setting aside, and we've asked lawyers, are the timeframes set out in Rule 26 good? And sure, they're great. Did anybody ask them, do you think your cases are taking too long to resolve? Because I think there's a disconnect in some lawyers' minds. They think they're getting them done within the timeframe set in the rules, and that those timeframes are fine. Did anybody say, are the timeframes in the rules good? And is it taking too long to dispose of your cases?
We didn't ask that in the survey. We did ask that because we had some of the preliminary results when we were doing the focus groups. And what we were hearing, and those were by and large very experienced lawyers, part of our focus groups. They were saying that that they thought that they were taking too long. Yeah, to actually get some of those cases done, and part of it was non-compliance with the rules themselves. Yes.
I was just gonna make a comment, and this discussion obviously needs to take place at another time in different committees, but there is some low-hanging fruit here with regard to when the COR is due and the different practices around the state where we could streamline this. If there's a gap of time that's allowing a big delay, you know, we can't control the delay between our final scheduling conference and when we set trial. You know, that's a limitation. And we also know that those cases, just because of human nature, are settling right before trial. You know, the settlement period is almost the same as the trial date for reasons that we have all recognized. But there is this piece of time when the COR is due and when we're actually getting the people in front of us to schedule the trial, which is when sort of the set the disposition. And if we could have a statewide practice, whatever it is, whether it's an order to show cause or a notice of intent to dismiss or a settlement or a scheduling conference that is virtually the same as the COR due date, that's at one place, that's some low hanging fruit where we can slam that time period shut. And that's just a clerical practice that we could implement.
And that's where the CJA actually, that we do, can back up the Supreme's rules.
Judge Levitt has a comment.
I was just going to say, I was part of a group here in St. George that presented when we amended Rule 26. It was at the litigation section get together here, 2012 or 11 or whatever. I don't remember what year it was when we first did it. But there was a robust discussion about why can't attorneys just stipulate around these rules, around the timelines and the proportionality of discovery. And we got into a discussion about whether there was malpractice implications, whether your client should know that you're doing more than the rule allows you to. But even then there was that discussion. And one person I remember specifically said, look, if there's not a final pretrial conference on the books, on the schedule, when that notice of deadlines goes out, we're not really bound to this. And I thought it was interesting that there were some attorneys that just felt like by stipulation, we don't have to abide by it.
On that happy note.
On that happy note. All right. Well, thank you. Thank you very much for allowing us to come and visit with you.
It's really interesting. Yeah, really interesting.
Really appreciate it.
So, well, it just, keep up the good work. I was like, come on, Utah. Y'all have always been on the front. You need to take you from the front place again. So. All right. But no pressure. All right. Thank you.
Thank you.